kick off. So welcome everybody to today's session on subpoenas. We've had almost 180 registrants, so we'll see if everybody joins, and it's great to see you. We've got a really good section of community workers here today, domestic and family violence support workers, community legal centres, psychologists, financial counsellors, Aboriginal caseworkers, saw some child and youth workers as well, amongst many others. So really warm welcome to you all. And for those who joined last episode, nice to see you again. The three of us presenting today would like to acknowledge that we're coming to you from Legal Aid's, well, Ray and I are in Legal Aid's head office, which is in Haymarket, Sydney, which is on the Gadigal land of the Eora Nation. And we would like to pay our respects to the custodians of the lands on which we're all joining from today, and thank Aboriginal and Torres Strait Islander people for their ongoing stewardship and education on how best to care for those beautiful lands, seas and communities that we're all very privileged to share. As always, just a little disclaimer at the outset for this webinar. We're going to be speaking generally about legal concepts. What we're talking about is not intended to be legal advice. If you are a community worker who's received a subpoena, you should be speaking to your peak body or a private lawyer about that and what legal assistance you might be entitled to. We have Law Access, which is the referral pathway for people coming for legal advice with Legal Aid. So you're welcome to use that. They also provide referrals out if Legal Aid isn't able to assist. And because this webinar is being recorded and will be uploaded at a later date online, I just wanted to mention that it is designed for professionals working within this space, talking about these topics. If you're yourself have been impacted by anything that we discuss, like domestic and family violence or sexual abuse, and you'd like to speak to a counsellor, the number for 1-800-RESPECT, which is a national sexual assault and domestic violence hotline, is up on this slide for you to contact if you feel like you might need that support. So today's episode is a follow-up episode to our webinar that we recorded, the three of us, a couple of months back. So you got subpoenaed, what next? And thanks to those who are coming back the second time, the feedback we received was that you'd like to have a bit more Q&A and an open conversation. So this is what we're hoping to cater to today. Some of you have submitted questions in advance, so we're going to go through those first, and then we'll sort of open it up to live questions. But if we see some questions coming through that we also, are relevant to what we're discussing, then we'll respond to it then and there. With the last webinar, we did go into the steps of a subpoena process, how to respond, objections and going to court. So I'd be encouraging you, if you haven't yet watched that, to perhaps go back and have a look at it. It's on Legal Aid's YouTube channel. I've also put in a couple of other materials that you might be interested in. We've got a podcast about it, and there's some other webinars on related topics. So you will get all of these links later on in an email after the webinar is finished. So a little bit just about us today. I thought it would be nice to introduce ourselves. So Kerry and Ray have very generously lent their time again today to this topic. And what brings us all together, even though we're from different areas of law, is that we're all pretty keen on sharing knowledge and education. And we've all come across subpoenas in our work. So for me, I'm currently talking to you from the community legal education team, but previously for about 8 years, I've worked at the Coroner's Court representing families of the deceased. So I've seen a really broad range of records and case notes and sort of trawling through them, trying to identify what's happened and where things might have been done differently. And that includes questioning witnesses in court. So that's my background and why I'm interested in this topic. So Kerry, maybe do you want to explain where you see subpoenas and what your line of work and who your clients are?
Thanks, Helen. So I work in the Sexual Assault Communications Privilege Service. I work with victims of sexual violence who are engaged in the criminal justice system when there's subpoenas for their health or counselling records. I get involved on behalf of the complainant or victim or witness, depending on the situation. I've also worked in some other similar sorts of areas. I've worked in the mental health law for a while. Obviously, saw lots of sort of quite sensitive materials, mental health and counselling materials through that role as well. So that's where I've come from. I've been doing this since about 2018.
Thank you. And Ray, what about you?
Thanks, Helen. Well, I'm a family law solicitor advocate. I'm doing these matters in children's matters primarily in the family law between parents, and of course in the care and protection space where the state is taking welfare action in relation to people's children. From my perspective, subpoenas are a very useful tool to provide us with that additional evidence when we're trying to assist the court in making decisions that affect the best interests of the child, decisions which often have a risk assessment attached to it. And if a risk is unacceptable and if that risk can be mitigated. And quite often the information you can obtain from subpoenas, properly used, can really help the court make those decisions, which are affect the impact of not only the adults but the children, and sometimes very little children. So that's my perspective coming from there. Outside of this, I've also volunteered in the past in community legal centres, so I have that aspect as well. And I also, like Helen, also have that community education lean as well, because beyond this, I also teach part-time at the College of Law. So I actually enjoyed being able to help facilitate that knowledge. So hopefully we can help you today with subpoenas.
Yeah, for everybody who's extra interested in the law and might like to take a law degree, you know where to find Ray to be your tutor. Okay, so today's agenda, one of the feedback that I got last time was that you'd like to have us break it down according to specific sectors. Now, there's going to be crossover, but I've tried to kind of break it down, your questions, and relate them to some different areas. So if you do work in one of the sectors and we're kind of on that page, feel free to then, jump in and ask us another question. Also, I might just say again, if our talking heads are getting in the way of you reading what's on the screen, just tell me in the Q&A box and I'll try and figure that out. So before getting on to the questions themselves, I just also wanted to invite Kerry to talk a little bit more about SACIT, because that was something we mentioned last time and there was interest in knowing a little bit more. So Kerry, could you just tell us what this communications privilege is, who it protects, and where it applies in Australia?
Sure. So look, the sexual assault communications privilege, it's been around since about 1995. In the current form, it's been around since about 2012. It's specific to New South Wales law because it appears in the Criminal Procedure Act. Other states have a similar sort of legislation, but they're not quite the same. It applies in criminal proceedings and AVOs only. It doesn't apply in family law or civil. There are very, very limited circumstances in which it applies in civil law, and I've literally never seen them happen. And we see most of these applications that happen in New South Wales. So I don't know that it's ever happened. It effectively creates a couple of barriers for using counselling communications in a criminal proceeding. Basically, that they're not admissible, can't be used in court unless either the counselled person consents or the court gives leave. It gets fairly complicated fairly quickly if I wanted to talk about how it actually worked. But the very short version is that if you think that the sexual assault communications privilege applies to you, that is, you're a counsellor, social worker, psychologist, psychiatrist, or community worker doing counselling, and you are subpoenaed for records in a criminal proceeding, and you know that the person you are counselling has been a victim of sexual violence, it's quite likely going to apply, and you should get some legal advice. And that's actually something that the SACP service can give you advice about. So that's what that email address on the screen is for. So if all those things apply to you, we can actually give you one-on-one advice about that.
And
or point
Kerry,
you to another place if you need it.
Can I ask, so when someone receives a subpoena, are they going to know that it's part of a criminal trial as opposed to some sort of other court process? How can they find that out?
So there's a few different ways, and the best way is just to read the subpoena because there's clues in there. One of the things is that it might say criminal jurisdiction somewhere in the subpoena. If it's in the district court, it will usually say somewhere in the District Court of New South Wales criminal jurisdiction, and that's a clue, or it might say Supreme Court criminal jurisdiction, and that's another clue. The name of the proceeding is going to be a big clue because if it's criminal, it's going to say either R and or the King and. If it says police and, it might be, but it also there's a few other situations when the police as a party are not necessarily criminal. But if it says R and the King and or police and, pretty good chance, and that's the sort of situation where you might want to contact us for a bit more help. And we're happy if you can email that subpoena to us. You can redact your client's name from the subpoena if you want to before you send it to us. But please don't redact everything, or we're not going to be able to tell you anything about the document. If you take away all the information on it, we're not going to be able to tell you anything about it, unfortunately. But your client's name you can certainly delete.
Well, that's extremely helpful. Yeah, should I move on into some of the questions on this topic? Oh, sorry, I just saw something. Yeah, will we get these slides? Yes, you will get a copy of an abridged version of these slides. All right, so Kerry, back to you with some of the questions that we received in advance of this webinar.
So I mean, I think I've already partially addressed this first one. So, I mean, the sexual assault communications privilege, you need to know that the counselled person has been a victim of sexual violence. Even if the counselling you're doing is not about that, the privilege is still going to apply. So if those things that I mentioned before all apply, you have a counselled person who's been a victim of sexual violence, there's a criminal proceeding in which they're a witness. They don't have to be the complainant. They can also be a witness in the proceeding. And there's a subpoena for your records. That's when the privilege is likely to trigger, and that's when you should get advice as quickly as possible. You do need to obviously respond to the subpoena. You can't just go, oh, it's privileged, so I don't have to do anything. That is not a very good idea. You do need to respond to the subpoena, but get some advice from us. And we can also direct you if you need further advice. And there's situations in which we might ask you to talk to your client, refer them for a representation from us. But we'll chat to you about that. Those are all specifically what's happening. But I think the very short version is recognize when it's applies and when it's applies to a subpoena you've received, and know when to contact us. Contact the Sexual Assault Communications Privilege Service for advice is really the key answer there.
While you're just making that point, there is a question that's come in to ask, would a domestic violence support worker working with victim survivors be classified as a counsellor for that purpose?
So the definition of counsellor is really broad. It's a person who has training, study, or experience relevant to the process of counselling persons who have suffered harm, and they listen to and give verbal support or encouragement, or they advise, give therapy to, or treat the person, whether or not for fee or reward. So that's very, very broad. A DFV worker very frequently would, I think, count as one. Social workers are generally accepted too. And if what you're doing is very similar to social work, then it's likely that you are going to. The real trick is that it has to be confidential counselling, which generally means it's one-on-one. There can be a support person there or an interpreter there or something like that. That doesn't make it not confidential. But if you've got those things happening, then it's pretty likely that it's going to be privileged, or you're going to have a counselling relationship. If it's about their emotional or social well-being, basically, as opposed to sort of physical well-being. If you're only taking information from them about something that happened, that's probably not going to be enough by itself. So the difference there is, I think, I often see that triage notes when you go to a hospital aren't privileged, but then as soon as you see the social worker and go more into depth about anything, or see the doctor and go more into depth about anything, then it does start to apply. But when you're only sort of getting your very initial assessment, it doesn't. So it applies to all counselling communications. Just for the second question here, it doesn't just apply to the information about sexual assault. So counselling about any issue is going to be covered. The sexual assault part only is sort of the threshold test. It's like the step you have to get over in order to get the privilege in the first place. It doesn't decide what's privileged. It only decides whether the privilege is available at all. If you're going to claim it in response to a subpoena, as the counsellor, you can claim it. The counsel person can also claim it. The best way to do that, we'll give you advice about this if it comes up, but if you are very sure that it applies, one of the things you do is you just write to the court and say, the sexual assault communications privilege applies to this subpoena, and would help you with the drafting, but it would say something like, we're not able to produce in response to this subpoena, and that's a consequence of section 298(2) of the Criminal Procedure Act, which says that you can't produce documents in response to a subpoena without leave of the court if they're subject to the privilege. If the court's granted leave, you do have to produce, which means that somebody's already claimed it and the court's already determined it.
Okay.
So, yeah.
No,
so
you go on. I was
I can just keep
actually, there's
rolling.
a question. Yeah, keep rolling, but there's one. So
There's a similar one.
yeah, a similar question here if you want to.
Yeah, so I'll find that. So generally speaking, if you're subpoenaed for your records, there are some circumstances when a report will be enough, but most of the time they're going to actually want the case notes.
So we're talking about here a psychologist who has been seeing a patient and they're wanting to know, do I have to submit all of the notes throughout the duration, or do I just need, or can I summarize it essentially? Can I provide a summary?
It's very much going to depend on what the court or the person subpoenaing you is looking for. It's pretty common, for example, for an organization like, say, for example, probation and parole. If you are assisting a person who's on parole and their probation and parole officer wants information from you, they're going to be pretty happy with the report because they just want to know has the person been turning up? Are they getting treated? Is the treatment, is there a good prognosis for the treatment? That's really what they're after, particularly if you're treating them for something like drug and alcohol issues, or you're doing a behavior change program, or you're doing something along those lines. What's important there is that the person is attending treatment. If you've been subpoenaed for your notes, they're much more likely to be after, what did they say to you? When did they say it to you? Did they tell you about this thing at all? Rather than your opinion about it. It's going to be about a fact rather than an opinion. And reports are ultimately tend to be a bit more about your opinion about something, or your summarization of something that's happened in therapy or in treatment. And that's not necessarily what the court is after. There are times when a lawyer will want a report from you and they will be asking. I mean, you can always ask, can I do a report for this? But I think you could probably expect the answer to be no most of the time. They'll actually want the notes. You're much more likely to be able to limit the notes they get by saying, what notes do you want, as opposed to my hundreds and hundreds of pages, because I've been seeing this person for 6 years. And you probably don't really want 180 sessions about, their fight with their neighbor, or the difficulties they're having with their stepmother, which has nothing to do with the criminal proceeding.
So what parts of notes can be set aside, or how do you go about asking that, certain matters not be included in what gets disclosed when subpoenaed?
So this is also going to come back to sort of what the person is looking for. So in order to subpoena something, it has to be relevant. If material's not relevant, you can ask for it not to be looked at. That's a decision the court makes, because it's a type of objection. You can also ask for a few things. You can ask for limited access to the material, for example, but the key to all of these is you still have to send it all. The trick is to say, separate out the material that's particularly sensitive into a separate envelope, and just with a cover letter say something along the lines of, this material is very, very sensitive. It would cause harm to the person if it was generally accessible, and either ask for no access, or, so for example, access only to the lawyers, for example. Both of those are things that you can do and get some success with, depending on ultimately what they're actually after. If the notes that you are asking them not to use are notes about serious sexual violence, and the proceeding is about the sexual violence, that they're going to use it. They're not going to agree that it can't be used because it's exactly what they want to know about. So a lot of that is actually going to really depend on the situation, what the person subpoenaing it is looking for, what the proceeding is about, and the contents of the notes. If you want to do that, the best way to do it is generally to separate out the material you want kept aside or kept more private, and ask for limited access orders to that particular part of the material. And you can do that with multiple envelopes and cover letters if you want to, and ultimately then it's up to the court how they actually handle that.
So that's a really common question that we've received during the course of this, the preparation of this. It pretty much relates to people in every sector is, what do we redact? How do we redact? Should we redact? So Kerry's really talking about how the advice we've given in this session and also the last session was really much about, well, what's being disclosed is being disclosed to the court. It's then the court's decision about how that material gets used, but it's important that you comply with the obligations of the subpoena, right? That's the obligation. It's going to pop up again a couple of times during the course of this, so we'll just keep repeating it.
My short answer is put your black texter back in the drawer.
Yeah, you can't redact material, unfortunately. There's very, very limited circumstances in which you can redact material, and you really shouldn't be doing it. I see it all the time. You often won't get called out on it, and the reason you won't get called out on it is because when we get it, we look at the notes, and what's been redacted we don't actually care about. But if we did care about what was underneath that black box, you would get a very, very cranky letter immediately, probably with a further court order that you produce an unredacted copy. I mean, ultimately, there was a question as well, and I think this kind of relates to it, a question as well in here about how documents were stored, subpoenaed material was stored after the proceeding was over, which I think it does sort of tie into this. There's a number of legal obligations about the way that subpoena documents are stored. Court documents are only ever accessed in accordance with the court order. If a person or if a lawyer is allowed to keep a copy of it on their file, it stays on their file. There's an undertaking, and if you're familiar with how a legal undertaking works, it's kind of like a really strong pinky promise that a lawyer makes, except that if we break it, we can lose our ticket. So we tend to take them extremely seriously. It's called an implied undertaking. It's got a few different names. It's called the Harmon undertaking. It's also called the rule in Hernon Street, which is the usual lawyer way of giving things really complicated and obscure names. But basically it means that if you get subpoena documents, you can only use them in the matter that they were subpoenaed for. You cannot use them in anything else unless you specifically ask the court for permission to do so. And you need to get permission from the court that originally subpoenaed it. And that's because it's in the court's control. The person who issues the subpoena isn't the one with control of the documents. The court is the one with control of the documents. So sorry, go ahead, Ray.
I was just going to say, can I just dive in on the end of this and say, in the family laws circles and in care and protection, there's usually an option for people who are producing the document to say at the end of the proceedings what they want done with the subpoenaed material. Do you want it back or do you want it destroyed? In terms of the family law court, the undertaking's actually gone to a new level above what Kerry was just saying. So now, and this is born out of COVID, we're expected to produce often tender bundles of subpoena material that we intend to rely on at trial, which means we need to be able to uplift and copy. And when we do that, we need to actually provide a signed written undertaking to the court that not only has the declarations that Kerry was just saying, but also says at the conclusion of the proceedings that we will destroy those documents. And I can advise that last year in the Family Court, well, Federal Circuit and Family Court of Australia, sitting in Melbourne, this incident actually came up. A practitioner was found to have not followed their undertaking, and then they were referred off to their law society for disciplinary action. So it is very serious. Sorry.
And just while we sort of tie off on this topic, a question is, as a service, can we redact staff names in a subpoena request?
Look, in theory, you shouldn't. Or rather, I'm not seeing necessarily why you should. I can understand why there'd be certain concerns. For example, if you're a domestic violence service and you know you've been subpoenaed in a criminal matter by the lawyer of the person who's been alleged to have caused violence. Generally speaking, the accused themselves isn't going to be getting a copy of the subpoenaed documents. They're allowed to see them. They will not normally be sent a copy. It would be unusual for that to happen. This is evidence that the lawyers are going to look at, and they're going to show them, but they're not going to be, it's not like they're going to get every single document that's involved in the whole matter. A person who's involved in a proceeding and is represented is entitled to get a copy of, for example, any court file documents, any evidence against them, so brief items and so on, statements and that sort of thing. But they don't normally get a copy of subpoenaed material. And it's quite common with sensitive material that the court will overrule that they can't be given a copy as well. And that's something that we ask for fairly regularly with mental health records of a complainant, for example, or counselling records of a complainant. We just ask the court to make a rule that the accused can't even be shown it unless they're getting instructions about a particular part of it.
Well, I think it's a pretty good moment. We're going to move on to this slide because getting some questions through from the audience on this topic as it relates. And obviously, this is getting into the concerns that a lot of people have about perhaps not just staff safety, but also predominantly the safety of victim survivors. So a few questions that we've had in advance, and this one came through quite a bit last time as well, was how can we protect a victim survivor's information from not being disclosed to the person using violence and their solicitor?
So my understanding, just before I do this, there was one last question on the previous slide that we didn't do, which is how long do you keep information about sexual assault? And the answer is going to be the very traditional lawyer answer of it depends. It depends on who you are and what you're doing. There's going to be legislation that governs your profession. So it may just be the Health Records and Information Privacy Act, which is probably going to, which is generally speaking 7 years, but there's some other considerations depending on what you're doing. And government currently, particularly if it's sexual violence against children, it's indefinite. Governments are keeping those records at this stage, basically for the 100 years, is what it looks like we're going to be keeping them for. They'll be destroyed at the end of that. And that's another consequence of the Royal Commission, that so much information had been destroyed about, and it was very, very difficult to do a lot of research. So that was one of the recommendations, or one of the approaches the government's taken, is at least government materials being kept indefinitely. You aren't going to be criticised for keeping things longer than you have to, but yeah, a lot of the time if we subpoena somebody and it's been over 7 years, we go, well, they might still have it. And we ask, maybe you do, maybe you don't. Anyway, so onto this slide. So I understand this is in the context of men's behaviour change programs where they are in contact with both the person who's alleged to have caused violence or has been shown to cause violence and the victim. So the difficulty there is that because you're talking with another person, you need to keep records of what you're doing. Now, if those records are being kept as part of the file of the person causing violence, then a subpoena for the file of the person causing violence is going to capture them. So this is the answer to this question is very much, how are your records organized? You could also do what I suggested before, and you could separate out these records and ask for limited access to them if they're subpoenaed, for example. But if you're providing services to a different person, there's also the potential for those services to be recorded in a file for that person. If you're providing information to a person, it's going to depend on exactly how you're organized and what it is you're doing. But there's also the potential for keeping that information in a file that's related to that person rather than to being the person causing violence, and have the files be linked, but not the same file. That's the only situation I can think of when a subpoena for the file of the person causing violence would not capture the information about the victim. But if they subpoenaed you and asked you for all records that related to the person causing violence, it would, because the records of the communications with the victim are going to be related to the person causing violence. So a lot of it's going to very much depend on what you do, how you're organizing your information, how you're actually talking to people, and what you're actually asked for. Because a lot of the time, if they just said the file of so-and-so, then no. But if they said everything related to so-and-so, then yes, it would probably capture it. So it gets a little bit tricky at that point.
So I think sort of these sort of questions seem to sort of relate in. Oh, Ray, sorry, were you going to add into that?
I was just going to just say it also depends upon the structure of the program, because from a family law space, so often a men's behaviour change program is looking directly at the perp, and so may not have any interaction with the victim as well. Just so I think it depends on the nature of the program and how it's structured and what service is being delivered, if that makes sense.
Yeah, and one of the comments we've had actually come through is from someone in a men's behaviour program said that they do keep separate files within the same case. So these sort of questions sort of relating to, I guess, what we might have already touched on, but about, well, redacting and risk management. And I suppose, Kerry, you sort of already mentioned the availability of being able to write to the court with a cover letter and explain a rationale, which I think we now understand to be like, yes, that is acceptable to write into the court and provide a rationale. But is there anything more that you can say about how people can go about protecting? For example, someone has mentioned within the context of men's behaviour change programs, whether admissions of violence, which might be detailed in a checklist, should be left unredacted in subpoena responses when children are involved, because exposure to domestic and family violence is considered a risk of harm.
I think
the answer to that is yes. You don't redact that. And in fact, I cross-examined somebody on that list last year. And in a simple situation was, this was at the partner of the party. The party had said there'd been no family violence in their new relationship. And then when this checklist came out, that it had all these allegations of violence. And so I asked the person were they talking about a previous relationship or their relationship with the client? And they said, oh no, that's the relationship with the client. And so it was a very important piece of information about working out the best interest of the child.
I just wanted to mention as well, for some guests who might not be aware, you can also ask questions anonymously. So sometimes when we type a response or we answer the question live, it will be displayed to other participants within the chat, but it's not going to be displayed later on online. Just a reminder there that you can use that function. So one of the questions that's come in on topic is, well, what about when the subpoena and the person requesting the information is the person who's causing harm? So self-represented litigant.
That's a Raymond question.
It may not actually be the self-represented litigant. It might actually be their solicitor saying, all files for Mrs. A and Mr. A. And I would say in that situation, you comply. And I am going to talk a little bit later about protected confidences, but the answer to this, and I think Kerry's going to be the answer, and I think this answer is going to remain the same. You don't redact, or if you do redact, you provide a clean copy in a sealed envelope with a cover letter, and you explain your rationale, because ultimately the court's going to make that decision. So I understand where it comes from, but again, the subpoena is an order of the court. This is what we've discussed in the previous seminar, and you have to comply with it.
Yeah, so I guess that point there that Ray's making, everyone, is that not to forget, obviously, in the work that you do, you have the safety of the victim survivors paramount in your mind. But remember that the subpoena is also imposing upon you certain legal obligations, and that there are consequences for you if you don't comply. So it's a dual consideration to have, and hence why communicating with the court about what your concerns are is going to be the best way forward. Ray, is it possible for people to ask whether the other side's solicitor only can have access? Is it at all possible to prevent the person from viewing the documents or taking a copy home with them? How can that work?
I think, thanks, Helen. I think that's a valid point. And what people can do is also lodge their notice of objection, or they can write to the court with the documents. I suggest lodging the notice and say to them that this is a sensitive material, and it's the same request that Kerry made before. So you either object to its production, or if it is allowed to be produced, that it's solicitors only. Now, of course, then you are going to have self-represented litigants arise. And so then the court is going to have to make a decision on that basis as to, first of all, should they have access or not? And then if they should have access, how will they have that access? And quite often when a self-represented litigant's granted access, it's in a limited sense, in the sense that they're allowed to view the documents in the subpoena room only. They're not allowed to copy it. They have to be supervised while they do it. So yeah, it is going to depend, of course, on the case, on the litigant, on the facts. There's no clear answer, but there are various steps, and the court will take hopefully the right action based on each one. But the onus is on you to flag your concern, so the court's alive to the issue.
And the courts do have obligations to weigh up those considerations. It's it is within the law that the court needs to be satisfied that that everyone's going to be safe throughout the process, and that's why these debates around how the subpoena can be used. Something that we talked about in further detail in our last episode was objections, what they are. There are certain categories of objections that you can make, and generally the advice is if you're wanting to make an objection about your case notes or records being disclosed, then do get legal advice around that.
While we're still in the family law space, I know one of the questions is, does this come under family counselling in the Family Law Act? And I'm assuming that's the 10D and 10E exceptions. And in my view, and it is just that it's a view, no, I don't think it is family counselling. But I don't know if that's ever been tested, because the way you look at it and how these things often come about could lend itself to that family counselling consideration. But in my experience, no, it doesn't count.
So before we move on, Kerry, is there anything else on this page that you wanted to mention? I think we've pretty much covered up off
I think so. There was one related question which didn't quite get answered, which was just essentially asked, if documents are subpoenaed, do both sides get to see it? And the answer is pretty much always yes. So either everybody sees it or nobody sees it. There's no, it's not there's no, but there are very, very few situations in Australian law where there's secret evidence, basically. Oddly enough, the sexual assault communications privilege is one of them, because only one side will see the documents until the court makes the decision. But it's pretty rare. Generally it means there's some sort of really quite strong privilege claim being decided by the court is the only time that people won't look at subpoenaed material pretty much straight away. It doesn't mean that the clients will necessarily see it, but the lawyers at least will see it. You can't just write to the judge and ask that the letter not go to the lawyers. The first thing the judge will do is hand it to the lawyers and go, I got this, what do you think? It doesn't, you can't just write to the judge and say, oh yeah, but don't tell the lawyers I wrote to you. That's never, ever, ever going to work. It would be an incredible breach of ethics for the judge to agree to that, basically, unless there was a very particular bit of law that said he could, or she could. But I think that's it for this page.
Yeah, now I'm going to move on. I'm also going to note something while we've got all the attendees here. It's 12:45, and if you do have to tap out at 1 o'clock, this webinar is being recorded and it's going to be uploaded to YouTube. You'll get a link to it, plus the links from the PowerPoint slides. So I just wanted to mention that here while we've got everyone. Okay, now we better pick up the pace a little bit to get through. Otherwise, some of our sectors are going to miss out. So children and young people, which is then going to be followed by health and allied services, got government and education to go, family law and court attendance information. So hang on with us. All right, now let's do children and young people. Not too much on this page, but Ray, could you talk to these questions around 16A requests?
Sure. Well, look, the first question is, what information should be redacted from a subpoena? You think you know our answer by now. Do we redact 16A requests and information obtained? No, you don't. Ultimately, though, and I will talk about this, a 16A request is requesting information that's going to go to decision making about the best interest of the care and welfare of a child. Now, on a rare occasion, you might have information that you might say will not assist in that any way, shape, or form. And on that basis, you should then write to the issuing party and say, I don't hold this information. And they may drop it or they may press it. That small little exception aside, the legislation requires you to comply, and it trumps any privacy concern that you may have. So you need to produce that material. So no, do not redact it. If you have concerns about certain information, again, have a conversation with whoever's requesting that information. And then maybe there is things that can be removed, but no, don't redact.
And we've shared here on this page a link that you'll get as well, which is got some great resources. It's DCJ, all about 16A, and what you can do as a service to respond to those.
And it is good information there, and that has all the details. So
yeah, that's fantastic. All right, I'm going to just jump on over to health. I've got one eye on the Q&A box. I can see someone's asked a question related to that, but we'll kick off first with just some of the questions we received in advance. So someone's asked, what about when working with people who are disclosing use of illicit substances? Should we be using particular words? Should we avoid using words? What should we do?
I think the first thing to say is, please don't try and tailor your notes with the expectation that you might get subpoenaed at some point. You are taking notes for a professional purpose, and they should reflect your professional purpose. But what I would do is I would avoid slang, and I would avoid ambiguity. So there are a whole lot of different slang words for drugs, for example, and some of them are not very clear. Some of them refer to more than one drug. Like, for example, I've heard clients use terms like gear quite frequently, and gear can mean any number of different things. It is most commonly used for opiates, but I've heard people use it for all kinds of different drugs. So it's just more a case of be specific. If you need to record it, record specifically what you need to record, and just try not to be ambiguous. And if you don't need to record it, don't record it. But if you need it for your therapeutic purpose, then record it. That's it, really, the very short version. And that's what the Health Records and Information Privacy Act really requires you to do, is to keep records of health services that you've delivered. So if it's part of your health service, record it. And if it's not part of your health service, then don't. But yeah, don't. If it helps, I don't think I've ever seen random records get subpoenaed in some unrelated matter that disclosed drug use, and then have, say, the police suddenly start investigating this person for possession of drugs. It's far too sort of small fry. It's not the way that things usually happen. But if somebody does have a drug problem, the family court, for example, is really going to want to know. But if they're getting treated for it, they're really going to want to know that, because that's if they've gone on their own accord to get treatment and they've been turning up and they've been reducing their use or controlling their use, that's really important information. If they say want to have it might be the difference between supervised and unsupervised contact 6 months down the track for your client. So you can't tell whether it's going to help or harm them either, because you don't know the context in which it's going to be used. So the best bet is just to be as accurate as possible, I think.
That's great. And what about patient consent when it comes to health records? Do you need to seek it if you're about to disclose their medical records?
Okay, very short version. If you have any kind of records like this, they're subject to a duty of confidentiality. That means you cannot give them to anyone. Then you say, well, what's the exceptions to that? And the exceptions are they've given their consent, or you have some sort of legislation or legal obligation that requires you to disclose it, like a court order, like a subpoena, for example.
Or 16A.
Or well, 16A is a little bit different, but we can let them read that themselves. Because 16A is very, very, what are you going to use it for, dependent.
Oh, that's true.
So a little bit different. Whereas a subpoena is just like, this stuff, give it to us. And you don't really get a no on that. So if the client not wanting you to doesn't mean that you don't comply with the subpoena, we'll put it that way. The client consenting to release of information, well, that also overrides your duty of confidentiality. But ultimately, you've got one. And unless somebody can explain to you why it's been overridden, you shouldn't be giving anybody any records at all. Next question again, redaction. No, please don't. Not for subpoenas.
I thought that I'd just keep including it because it got asked so often, and we can keep
It's
keep
very,
saying
very
the same
common.
thing over and over. Yeah. So also for medical and allied services, no, still no redaction, still not allowed to wield the big black pen.
No, I think literally probably the only thing that you'd ever be redacting, even so, there's some quite strict legislation around things that shouldn't be produced under a subpoena, for specifically around mandatory reports, for example. But what you should do with those is put them in a separate envelope and say, this document, like on this document, I've redacted the name of a mandatory reporter and the contents of a mandatory report, and the unredacted document is in this envelope. And you should hand them both over. And it's quite likely that the court will just go, well, I can't give you this because 108, I think, I can't remember which section it is, the Children and Young Persons Care and Protection Act says you can't. 28.
Yeah.
Yeah,
I think that also sort of answers more or less the you're talking about exemptions. Well, someone's asked exemptions to subpoena requests.
Yeah, so really exemptions only apply if there's legislation that says things like cannot be produced by any other process, which is really it's very rare wording. Most of the time it might say something like it's inadmissible, which means they can have it but they can't use it in court. But you still have to produce it under a subpoena. It's just never going to be in evidence.
Yeah. In between here, little, I guess anecdotes. Would we all like to share maybe a little anecdote? What's a common mistake in documenting? How does it impact proceedings?
Yeah.
You're only allowed to choose one, though. You can't just.
Oh, look, it's just a common theme. You see somebody saying, I've gone off and seen a counsellor, or you get a report, somebody's got a counsel report saying, Tim's been doing great at counselling. And then when you read into the counselling notes, they're not documented very well. They have the opinion through them. And I think we covered this in our last slide. It's really not helpful. You just got to be with a straight bat, record what you've been told. So, instead of saying, oh, then Tim was bashed by somebody, you can say, Tim reported to me that this happened and then this happened. So, keep your opinion out of it, keep it objective. That's probably the big mistake I see coming up in documenting things.
And I can speak to it. The coroner's court, common things that pop up that then have to get trawled over as timestamps, keeping your progress notes up to date, no retrospective notes, avoiding sort of biased or prejudicial type terminologies like malingering, keeping it objective, contemporaneous, explaining your rationale, and just be aware when using abbreviations that not everybody outside your sector is going to understand that. So, all right, I'm going to now, unless Kerry, you wanted to mention anything, I'm going to go on to government and education.
I think I already sort of talked about that when I talked about ambiguity and slang about drug names. The same sort of thing apply. Just accuracy. Inaccurate notes are really, the sort of things I work in. I'm not going to share any anecdotes because all the notes I read are awful. But yeah, I've seen things get really, really difficult because people have used euphemisms or they've been ambiguous. I think that sometimes even people have been a bit, unsure about how to write something down. So they've kind of use this really couched, careful language around something, but it's actually an allegation of really, really serious sexual violence. And the fact that they've used such softly wording makes it look much less serious when the way it's been disclosed. And then people say, oh, well, you know, this looks a bit inconsistent. Why is this written down like this when you've said you've told them all these other horrible things that happened to you? So I guess just accuracy, just try really hard to be accurate with what you've been told. Ultimately,
Yeah.
your notes are not going to prove what happened. Like if you've been told about something that happened to a person, your notes are never going to be subpoenaed in order to prove that that thing happened. They're going to be subpoenaed to prove the person told you something about that thing. That's the difference. And it's a really, really subtle difference that I'm not going to go into because I'm not explaining hearsay in 5 minutes. I'm not explaining hearsay at all. It's awful area of law. But that's a very short version.
Hence law degrees and
Yeah.
why we've all suffered so deeply. And so, look, moving on now with government and education sectors, which I've sort of lumped you guys in together. I hope you don't mind, but some of the questions that came through were similar. Somebody asked, are there any government bodies that are protected by law and not complying with a subpoena, like the NDIS?
No.
No. Okay.
Oh, look, I mean, ASIO can probably get away with a lot, but they still have to come in. They still turn up and they just claim public interest immunity over a lot of their records. So, yeah, secret squirrel type stuff, I guess. But they still have to turn up. They can't just get that.
This one is, so when an organisation has received a referral that's come through from, for example, child protection, and if they get subpoenaed, do they need to provide that original email correspondence?
Yeah, is the answer to that one, but it also depends about how the subpoena is structured as well. So
this also might go into that mandatory report issue as well.
It could also fall into that one. But as a general rule of thumb, yes. If it's a document that you hold relevant, that's covered by the subpoena, then you have to produce it.
Yeah. And for everyone's information, emails are considered to be part of the file. Yeah. So at school, Kerry, can SACIT protect school counselling?
Yes, short version.
Short version's
Absolutely.
good. And
also, occasionally some people who are not necessarily school counsellors. So year advisors, so student support type workers, if they're doing something other than purely academic support, then yes. If they're talking to kids about, emotional or social stuff, then it can. It just needs to fall into those categories I talked about before, where it's confidential and so on. But yeah, school counsellors definitely do.
I think there was a question just earlier, which we might have covered, but perhaps it was someone had asked, just a reminder, does SACIT apply to the entire file or just the bits that
I typed an
answer
to that one, but it applies to everything that's a counselling communication. So things where you record what a person says to you or what you say to a person or what you say to another counsellor. So like writing to a previous counsellor or to their GP, if you're doing like a mental health care plan report update, for example, those communications are all going to be. But things like all the receipts for the Medicare rebates, they're not, because they're not a counselling communication. That's an administrative document. So texts about, oh, I booked you in for such and such a time. But a text that says, oh, hey, I've had like a really horrible day. I really, really need to talk to you about this thing that happened. Yeah, that would be privileged.
So that's that key terminology there that's applying is the
counselling communication.
Counselling communication. That's the bit that's up for protection. And what if someone looks in their file and they don't find the records that are being requested? Do they need to respond?
Oh, yeah, you just tell them they don't have anything. If there's no difference between I don't have anything and not responding and ignoring you, and courts do not like being ignored, they will put up with it for a little while and then they will stop putting up with it very quickly after that. So
yeah, and it just needs to be a short note that says, I received the subpoena. We don't hold any files in relation to your request. Thanks for coming.
Yeah.
That's right. No ignoring subpoenas, everybody. No head in the sand. And lastly, is there any way to block a subpoena from being issued in the first place?
In SACP, yes. Everywhere else, no. SACP has its own special rules and regime. But generally speaking, no, you cannot stop a subpoena from being issued unless you talk to the lawyer before it's issued and ask them not to, and they agree. That's pretty much the only time it's going to work. And sometimes that can be things like, I mean, one of the things I sometimes do or suggest to people to do if they're going to be subpoenaing someone is call them up first and go, hey, look, I need to issue a subpoena on you. This is the sort of stuff I want. I don't want to waste your time. So what's the easiest way for you to get just the things I'm after? Which I think is really a pretty good way of doing it, because then they don't end up with this stuff that has no probative value or is about completely irrelevant things. And I think, it's a productive conversation to have. I understand why you might not want to have it with a random lawyer that rings you up, because obviously you can't tell them anything about what's in your file at that point, but you can tell them things about how you hold information. But you can argue that a subpoena doesn't have a probative value. It's called a no legitimate forensic purpose objection. It's very hard to make if you're not a party to the proceeding. So you're really just a witness if you're sending in documents. You don't really know what it's about. You don't know what the main issues are. Sometimes it's obvious that what you have doesn't have any relevance at all to the proceeding. And that's when you could, in theory, make that objection. But you wouldn't say it doesn't have probative value. You would just say it's not relevant. Because that's the standard. If it has literally anything to do about the proceeding at all, it's relevant and you can't object, basically, on that. The probative value, legitimate forensic purpose is enormously broad, particularly in crime.
So we're going to move on now to family law. Now, just before we do, because it is just 1 o'clock, and I'm conscious that some people might not be able to stay with us. So I just wanted to mention, if you do need to go, I just flipping forward for a second. We have an upcoming webinar, which is about property, some new property changes in family law, and part of that webinar is going to speak to the new protections for sensitive information. You'll get that link on how to register later. So I just wanted to flag that with you now, if anyone's going to head off. And I also just wanted to mention there's another webinar coming up about protection visa applications next week. All right, now heading back to family law as a general topic. We received plenty of questions here, and this is Ray's special area of expertise. And there are some questions in the Q&A box which perhaps we haven't yet answered. Either Kerry might type in a couple of responses now while Ray's talking. Otherwise, we will come to them when we get to a slide where we're just going to tie up any loose ends, basically.
I think we've sort of covered a number of them. One of them I might just start with is subpoena is only about some children in the family. Split family, can we then redact information that's not about the information requested? Again, I think you know your view about redacting, but if it's a situation where your notes are covering other kids, first things first, talk to the party who issued the subpoena and say, hey, this is going to capture this. Are we able to agree on what can be produced and what can't be? If that fails, then, and you really want to redact it, it's that same process where I would suggest you provide a clean copy in a sealed envelope and a letter explaining why you've done something, and then the judicial officer will make the decision. The thing is that you're saying it's a split family, so obviously those children aren't covered, but again, you don't know what the case is about. So it actually might cover those children as well in a way. So that's my answer to that one. So sorry, come back to the slides. If a federally funded family law counselling service protected under section that first question was a bit of an interesting one. So I think when I was reading it, I think to disconnect the funding from it, the real question is, are you providing a family law counselling service? And if the answer is yes, well then 10A, section 10A D does apply. Well, my reading of the legislation is that you're still required to comply with the subpoena, but the subpoena evidence then, if it does apply under 10E, can't be used as evidence. So in that situation, I would write the notice of objection and say, I don't want to produce documents because this is all going to be captured under that objection. I think that's the easiest way to deal with that. Ultimately, if the court overrules you, well, then you can produce the documents. I think the next one is about, what do you think about when wanting to negotiate or request narrow the terms? I think we've already covered that.
Yeah.
I hope. What is the
And
process?
and reminding everyone, you can pick up the phone and you can talk to the other side as well. Find out a bit more and explain where you're coming from too. See whether that works.
And I know we're all terrified of the phone these days, and prefer emails, but no, it is worth having that chat.
Looks like that. We still have them at Legal Aid, just.
Barely. What is the process to issue a subpoena in family law proceedings listed for hearing? It's an interesting question. I don't really want to go into it too much because I think if you have a lawyer, for people complying with it, you shouldn't need to really know how it's issued. But in general terms, if you're approaching an interim hearing, parties usually have leave to issue 5 subpoenas each. For things like a final hearing, or if there's no actual hearing date set, parties usually need leave to issue a subpoena. And in that situation, the court will ask, well, why do you want to issue this subpoena? The other thing is, of course, 67 ZBE requests, which are things to police and DCJ and the like. And the legislation now says is that if that request has been made and the documents produced, a party can't issue a subpoena to them without the leave of the court. That's the rough general process in which we work under. If you're looking at the processes to, well, how did we work out to issue that subpoena? Well, that's obviously going to be dependent upon the facts of each case. So, but I don't want to linger on that because I don't think that's helpful. The next one, are ADVO conditions served by family law court orders? Well,
so this wasn't about subpoenas, by the way. It's just a question that came up a few times, so I've popped it in since we've got you here. So just you can answer it very briefly.
I am going to answer it briefly, and I think I'm going to upset some people and say that kind of, yeah, they can. 68Q is your place to go to on the Family Law Act. And what happens is if there's an AVO in place, then obviously the parties have had to disclose this, the court has to be made aware of it. And if it's going to make an order that's going to conflict with that ADVO, it has to give reasons as to why. All the parties then have to also be put on notice of that, including the protected party, and the registry, once it does make that order, has to notify the court that made the original ADVO and has to notify the police in that area. The reasoning behind all this is that if you have the it's chicken and egg stuff. You have the ADVO before the final hearing, then the courts have that opportunity to consider all that other evidence in terms of a best interest context of the child. But we all know that just because there's different orders in place doesn't stop people continue being perpetrators of violence. And so the flip side to that is 68R, which is if an application is brought, say the person continues acting in a violent behaviour subsequent to that, and a new application is brought before the local court can actually vary or suspend the children's orders. So there are 2 sides to that. That's a very brief overview on what's a pretty complicated subject.
And I know that people don't like hearing a little bit about a topic and they're not being able to hear more. But on this topic, we do have already, Legal Aid's got some webinars about AVOs. There's also a podcast that we have out, which is the episode series is called Till the Violence Ends. So check out those. Links are in these slide packs. So there is more information out there on this particular topic of interest. Now, I think the last question we've pretty much answered on previous slides, so I'm not going to go there. Oh, sorry, was there something else?
No, we're going on to this next slide. That's fine.
I just wanted to ask Ray if he could snapshot us. There are some very recent changes in the last months, changes in family law, and one of them is going to be about sensitive information. Could you just give us a real short, description of what's happening there? I mean, as much as you can, and bearing in mind we are going to have a webinar on this topic, which we will delve into further detail.
So the phrase we're going to use for this is called protective confidences, which could cover, for example, the kind of confidence you'd get in a sexual assault privilege type matter. Now, as of the 10th of June, we've got new amendments to the rules and the Family Law Act. Sorry, I'm just looking to the side because I've made a bunch of notes on this. So this is all brand new, and so it's going to be couched in a little bit of I don't know. We're going to have to see how this one plays out. But where we're looking under is Part 11 of the Family Law Act, which covers sections 102BA to 102BF, I think, which talks about protective confidences. And in terms of those protective confidences, we're talking about things that are disclosed in counselling or the like. And that people who can object are parties, children's lawyers on behalf of children, and of course counsellors and the like, as to not wanting to produce the material as it covers a protected confidence. Now, given that this is family law, the overriding principle that when we're dealing with children's matters is the best interest, and these new sections are couched very much in words such as may, and also cover certain tests that the court has to do if these objections are raised. So, for example, it will still weigh up, will the harm caused be outweighed by the benefit to be able to make the correct decision for the child? Is it that prejudice versus probative argument? It's more complicated than that. This is very, very small snapshot. Now, the question is, well, how do I raise this? Well, if you're a party, they can lodge an application. The ICL can also lodge it on behalf of the child. And of course, if you're producing material or being subpoenaed, you can lodge a notice of objection and point this out as why you don't want to comply. Ultimately, though, the court will still be the final decision maker in that, and the court may, in the end, say you may have to comply with that material. Now, the question is how will it really work in practice? And of course, nobody can answer that. I think on one hand, because best interest still applies, that it still have these tests that theoretically have existed with these kind of objections previously, that maybe it won't apply as strongly as people think. However, I think anybody who's listened to what the Chief Justice has had to say in terms of family violence in any time in the last, I don't know, 2 years or more, will know that the court is taking these view towards family violence more and more seriously, and as it should. I mean, the Chief Justice has acknowledged, and rightly so, that family violence is the business of the family court. So I think how that plays out is really going to depend upon what confidence is being protected, how it's going to play out with the children. And I think that influence from the top down in the judiciary as to how they're going to view it or not. Now, that's probably cold comfort sitting in now going, well, I don't know if it's going to apply or not, but unfortunately, this is new territory in family law, so it's just have to wait and see. Now, I found last night, I was doing some reading a little bit of reading on this, and I didn't get it to Helen, but there actually is at the Attorney General website a fact sheet on this as well. So, sorry, it's not there. I haven't got it to put up, but go.
I do have it.
Oh, you do?
There's 2 fact sheets. There's one for clients. There's one for community workers, just like yourself. So I will put that on this slide when I send the abridged version. And yeah, it's a really great fact sheet, and it goes through all of the changes in very in
actually more detail than I just did then.
In detail, but not complicated to read and to understand how it all fits in. But it's great news. It's some of the biggest reforms that are happening in this space since, well, I don't know, a decade or more.
And I think if everybody who's watching this or submitted a question or whatnot, go back over those questions that you thought about and put that filter on it as well, because that might add an extra layer as to can I object or not. And it also saves me having to go back over the questions and re-answer it with that prism.
Yeah. So I'm going to go on to court matters now, and then we'll tie up any last minute questions. Now, I'll just put in this first one. It's a real quick response, but I'm originally from South Australia, so it's close to my heart. Who incurs interstate travel costs if subpoenaed to attend a court in New South Wales? That was from someone from SA. And the answer is, well, speak to the other party or whoever's issuing you the subpoena. So then what happens at an objection? Is there such a thing as a hearing about objections, and what can someone who wishes to object say?
Yes, absolutely. There's an objection hearing. I mean, you've asked the court to make a decision. Generally speaking, if the court's determining anything, anybody who has an interest in that decision has a right to be heard. So what you can say is, what's relevant to the court making that decision. It's a bit hard to answer that question because it's a bit of a what do I say to the court, and that's legal advice. Legal advice has to be about what you're actually doing instead of in a general sense. But yes, you do get to be heard. You can just write to them and say, I'm happy to just be heard on what's in my letter, and leave it at that. That's actually very common, and the court will just make up their mind. I think they do tend to give it more thought if you roll up, because you show how seriously you're taking your objection, as opposed to just writing to them. They'll consider it either way. They're not going to just tick a box because you haven't turned up. But I do think that they will take it more seriously if you are there. They'll think about it a bit harder, perhaps.
The next question, are there instances where a complainant might not receive a subpoena for a criminal law matter?
No, they always will. I mean, a complainant is a witness. That means they have to go to court to give evidence. And if you're going to court to give evidence, you get subpoenaed because it tells you that you have a legal obligation to go. It tells you when you're required to go. It tells you what court you're required to go to. Like, that's essentially how you get notice of the fact that you're giving evidence. So yes, a complainant will always get a subpoena. Usually the police will just hand it to them. It's not a.
And I was just going to say, in the local court, I've seen instances where the complainant hasn't received a subpoena, and then they've not given evidence, and then the matter has been dismissed. But that's because somebody, probably the police, haven't actually done their job and issued it. So it's always supposed to happen. If it hasn't happened, it's because somebody's not done something.
So it really should be happening. But then what happens if someone doesn't receive a subpoena?
Well, they won't know about it.
Okay, so that's two different questions.
It is two different questions. Hence why I'm asking just the first bit, because we've already responded.
Yeah.
The second one is not non-response is
different.
Is not a thing.
Okay, so receiving a subpoena, it's referred to as being served, and there's lots of rules about what counts as effective service, and that depends on what court is making the rules. Basically, there's different rules. Generally speaking, I mean, it's not like the sort of dramatic American thing where somebody slaps an envelope on your chest and goes, "You've been served," and walked off. But the principle's kind of the same, is that you have to have been confirmed to have received the documents in some legal way. And that can be leaving them at your place of work, leaving them at your personal address, handing them to you directly. And the person who's done all that is going to do a thing called an affidavit of service that says, on this date, I attended this address and I handed the document to the person working at reception and said, this is a legal document for so-and-so. So if they don't have that affidavit of service or something similar, they can't prove that they've legally served you. And if they haven't legally served you, then you can't have been proved to have received the subpoena, which means it doesn't compel you to do anything, basically. Or rather, it means that you aren't going to get in trouble if you didn't happen to comply with it, if you've been served incorrectly or badly. I mean, I wouldn't rely too heavily on that if you did actually get it, because they're just going to fix it and send you one that does comply with everything. So it's not kind of a get out of jail free card, as it were. But yeah, the short version is if you didn't get it, somebody's stuffed up really badly somewhere along the line. Yeah.
Sorry, I just skipped ahead by accident there.
So not
And
responding, that's a bit different.
Yeah.
So if you don't, okay, so a subpoena is a court order. It's basically a court telling you to do something. Courts don't have a good cop, bad cop. They only have bad cop. So basically they don't have a reward if you do things that you're supposed to do. They only have punishment if you don't. Courts will generally not apply sanctions against somebody who doesn't comply with a subpoena unless they're really annoyed at you. They can, and in fact, one of the reasons we've got the sexual assault communications privilege is because a magistrate stuck a counsellor in the watch house for 4 hours for contempt of court because she refused to hand over documents under a subpoena. That said, it's pretty rare. Basically, in order for that to happen, you have to ignore the subpoena. It has to get listed. The other side needs to show that they properly served you. Usually at that point, the court will say, we'll give them a call and tell them to get it together. The only time I've heard of recently where someone, and this is, I'll make this deliberately quite vague to not identify anybody involved, but there was a subpoena issued on quite a large company to provide some records to the federal court. They didn't respond, or they didn't do anything. The subpoena was reissued on them and they didn't do anything. And then there was an order to produce, which is basically when you ask the court to make a specific order that says, hey, you've had a subpoena, get on with it. We need this material. And they ignored it again. So there was no letter, no nothing. And the next thing that happened was the court issued a warrant for the arrest of the CEO of the company. And the documents turned up 2 hours later. So basically the courts are not going to, they only have a stick. They're not going to hit you with it if you make a mistake or if you do something, or you do something a little bit wrong. You're just going to be told to fix it. But if they have to tell you over and over and over again to do something and it's important for the proceeding, they're going to get mad at you. And if they get mad at you, that's when bench warrants come out, basically. And that's really the only tool they have is a bench warrant, which is go to the police, go find this person, bring them here, and they can explain to me why they haven't done what I've told them to do 3 times now. So you don't want to be that person. But the way of avoiding it is just going to be writing a letter that says, I don't have any of these documents, or I don't understand this subpoena because it's not the way we hold documents, or, whatever. There can be lots of different reasons, but basically it's just don't ignore it.
I mean, another one could be they didn't include the conduct money. So, but then still write to the court and say, they didn't provide me conduct money. Yeah.
If they don't give you conduct money, it's not valid. If they serve it on you late, it's not valid. Either of those, you don't respond. But the reason you don't respond is because they don't override your duty of confidentiality anymore, because they're not a valid court order. So it's a little bit, it's not so much of a, this is a type of subpoena I don't have to respond to, but it's like, well, this subpoena isn't valid. And if that's the call you want to make, you really kind of want to get legal advice before that's a big call. But if they don't give you conduct money or if the dates are all wrong, you can see that very clearly.
And just on the last dot point there, Kerry, is it right that, I mean, you can't insist how a subpoena gets served, but you can write back and say this was served last minute and I can't comply. I need more time, right?
Yeah, and email is generally not valid service unless there's been an order for substituted service by email. Normally, it doesn't have to be served face to face, but it does have to be served in a couple of particular ways, and email is not generally one of them. Usually people just accept it by email simply because otherwise it just takes longer.
And more often, there are certain obviously agreements between government agencies that will say, well, we'll accept it by email. But in otherwise, my experience is that when people accept it by email, it's because we've contacted them first and said, will you accept it by email? And usually they'll say yes, but we still want the hard copy.
Yeah. All right, now I'm going to go, I'm noticing people are, it's understandably probably wanting to go to lunch now, and numbers are dropping down. It's almost 1:30. Kerry and Ray, do you want to just have a little look in the Q&A box, see if there's anything in there that you feel that you're able to answer? While you do that, I'll just respond to one person's question, which is, can I get a certificate of attendance for professional development purposes? Look, I am happy to write you an email if you want to I'm going to provide an email on the next page that you can contact my team, the CLE branch, and I can provide you that. I don't have any particular special templates for a certificate. It will be a DIY job, but I'm happy to provide that.
Also, one of my colleagues sent me an email while we're talking, going, just listening to you, and pointed out that there are some other government exceptions when we said, oh, ASIO probably couldn't do it. And they noted that Centrelink has some, Child Support has some, the ATO has some, which is not going to affect probably most people sitting here watching this today, but there are other little exceptions, but they probably won't affect you.
Something else
I think if you have one, you probably know about it.
Sorry.
Yeah.
So, yeah, basically.
And just while I still have a bunch of attendees who've stayed on, thanks everybody. When you get asked at the very end of all of this, there'll be a little like a feedback form. I'd very much appreciate if you could put in there any suggestions, feedbacks, comments, not just about this one, but also ideas that you might have, subjects that you'd like to hear more content on. Because just coming off the back of speaking about the court processes for people needing to attend court, I have received feedback that a couple of people would like to hear more about, well, what is going to court like? People are afraid to do it when if and when they do get subpoenaed. So I'm looking currently at being able to put together a webinar on that topic, but there's plenty of other topics. As you all know, legal aid has got many practice areas. So yeah, do let me know. I do take it all into account. And this is the first of this type of webinar where we host a live Q&A session. So if you found that this format was good, or if you have suggestions on how to improve it, you can also give me that. Be kind, because like I said, it is the first one that we're running with this particular format. And as we're finding out, it got so many great questions to get through and so much to say. It's a really big topic. So again, thank you to our presenters for spending the time. All right, so back to you both. Anything further here that you'd like to answer?
There seems to be only two left, about conduct money and about costs, and I'll just deal with conduct money really quickly. Conduct money is your reasonable expenses in complying with the subpoena. So that doesn't mean professional costs, but it does mean, well, if you have to use your professional skills to do it, then yes. But if it's administrative, then and you're a psychologist doing your own photocopying, then it's not your professional rate. But it's things like photocopying costs, courier costs, and similar things like that. So it's going to depend on what it's actually costing you. So if you want to object, so if you have an issue about conduct money, the first thing you do is negotiate with the other side. They can agree more, they can disagree. If you disagree, you still need to roll up with the documents, but you need to actually go to court with the documents. But then when they say, is there an objection, you object to production on the basis that you haven't been given conduct money, and then there'll be a bit of argy-bargy, and if there's a huge argument, they'll set it down for a hearing about what your actual costs are. So it can get, yeah, it's going to be a huge time sink, honestly.
No, you're not going to get $5 a page for photocopying.
No, but you are going to get your whatever you, if you have to go down to Officeworks and do photocopying and they charge you 30 cents a page, you just put that invoice in there as part of what, and again, and there's not going to be a lot of argument about it in that situation. And the last one is, do you need to pay the subpoena issuer's costs if you object to the subpoena and lose? And the answer is, it depends. It depends on what jurisdiction you're in. In crime,
Not again.
Generally speaking, no, in crime, because the situations in crime when costs are available are very limited. In family law, they're much more common, and Ray can talk about those. In civil law, is one of the occasions when it's more likely that you could get costs against you, because in civil law, they much more usually follow the general principle that costs follow the event. That is, if you lose, you can end up having to pay costs. But they would need to apply for costs. If you run a really hopeless argument that was never going to get anywhere, that's when you're at risk of costs against you. If you kind of win on some and lose on some, you're probably not going to get a costs, almost certainly not going to get a costs order, because you were partially successful. It's just, if you lose to the got run over by a bus level, that's when you get costs against you, because the court is like, this has been a massive waste of everybody's time.
I think, Kerry, that actually sums it up nicely, including for family law. Because again, from my perspective, I've never seen anybody object to cost and then have a cost order made against them. This is not a party. I mean a one of the people being subpoenaed. But there's always an exception, and if that exception happens to be that you are running a particularly hopeless objection and have been warned about that being a particularly hopeless objection, then you do run the gauntlet. So yes with a but, no with a maybe.
Yeah, I think if it's that bad, the judge you'll get hints. You'll get hints from the bench about this seeming like perhaps not a particularly strong objection, for example, or they won't tell you directly. And it's a bit hard to pick up on judge hints unless you're a lawyer and you've done a bit of litigation.
Can I suggest though, if your objection's really that strong, go see a lawyer. Go get that professional advice about it. Because just saying I object may not be good enough. You may need to put something substantive forward, and you may need to be represented for it. So if you're at that level, go get that professional advice. Yeah.
So if it's that important, then that's unfortunately with a lot of things with law, law can turn into a bit of a put your money where your mouth is type situation, which is horrible. But it's the system we have, unfortunately. And some of these objections, as I said, objecting to a subpoena where it goes to argument, you're going to turn up twice to do that. And if you've got a lawyer, that's going to be a number, and it's not a small number, is the problem. So I think that
I think we're
that all the questions.
Yeah, I think
so.
We are kind of wrapping up right on 1:30. So as I said earlier, you'll get a abridged version of the slides. That means it's not going to contain all of the questions, because I don't think that that's very useful to know questions. It's going to be just the links and these contact numbers, etc. Thank you so much to Ray and Kerry, who obviously love talking about this topic and are happy to share their time amongst what is very busy workloads. So we can't wait to see you all again next time round, and shoot me an email if you'd like anything else. Otherwise, have a great lunch and a good weekend. Take it easy, and thanks again to our panelists today. Clap to them. Thanks, guys.
Thank you.
And thanks, Helen.